Good morning, Mr.
Good morning.
Now, as I understand it, you will take 10 minutes, and then Mr. Greenberg will have 10 minutes, and then Mr. Freed will have 10 minutes, and then Mr. Zell will have 5 minutes, give or take. You may proceed, Mr. Snyder.
Very well. Thank you, Your Honor. I am here this morning on behalf of Merrill Lynch. We are here today on the further appellate review, a petition of Merrill Lynch on the decision of the Appeals Court on a Rule 64 report from the Superior Court. Briefly, the facts. Benistar was a qualified intermediary acting under Internal Revenue Code 1031 to facilitate basically deferral of income tax by the plaintiffs. Merrill Lynch was not a party to any of the plaintiffs' agreements with Benistar. None of the plaintiffs had any accounts with Merrill Lynch or any contact with Merrill Lynch in any relevant time period. Benistar's claims were assigned by the trial court to the plaintiffs. The plaintiffs prosecuted them in arbitration, received a $12.6 million arbitration award, which has been confirmed by the state court in New York.
Yeah, can you help me out a little bit on this? The case against Merrill Lynch is being pursued because that arbitration award will not cover all the damages. Is that what I'm led to believe here?
I think that's the theory, although we don't have any explication of that.
If the appeals court is right on this notion that the, forget the fellow's name, Patterson, I think it's the Patterson affidavit.
Yes, that's one of the...
is out of the case because,
yes,
as the appeals court appears to be, because there was just an improper violation of discovery, not violation of discovery, but pursuit of discovery. The judge, Botsford, or colleague Botsford, flat out said the other affidavit would not support a grant of a new trial.
That's correct, Your Honor.
And that's the end of that, isn't it?
That is our position.
Merrill Lynch is out of the case.
That is our position, Your Honor. That is the second piece of the so-called
the
newly
appeals
discovered...
court opinion is absolutely wrong on her opinion, on her decision with regard to that Paley affidavit.
It is, Your Honor. It is absolutely wrong. She explicitly found that she could not, simply on the basis of the Paley evidence, grant a new trial.
Well, she didn't do it as explicitly as she might have, but that's the gist of what she said.
Well, we could always, in retrospect, in 20/20 hindsight, say we might have said this a little clearer, but I think she certainly made it absolutely clear.
Well, the case possibly reduces itself to a very simple 1-2 issue.
Exactly.
A, Patterson is out. B, judge said Paley wouldn't support it. End of case.
Exactly, Your Honor. We agree. And there are additional grounds that we contend that the Paley evidence, even if you were to ignore...
Well, then you get in that big snarl up of what do you do with these kinds of affidavits when, on the civil side, when somebody, in exchange from getting out from under an enormous judgment, does what this fellow did.
Well, that's our second problem, Your Honor, with this. And I suppose, based on the first point Your Honor made, there's no reason for the court to reach that, but were you to reach it, it certainly sets, we contend, a very dangerous precedent in terms of finality of judgments and the integrity of the trial system on the civil side. There are reasons... Particularly when the judges, it's not a case of the judge's discretion, particularly when the judge has more or less said she doesn't accept the Paley affidavit either. That's correct. That's correct. She did not accept it, found him to be an incredible witness, found she could not have granted the relief simply on the basis of his evidence. The appeals court, as Your Honor has pointed out, has said the Patterson evidence cannot be newly discovered, essentially because it was not newly discovered. And in that regard, they reversed her. They reversed the trial judge on that issue so that we are left here with the Paley evidence, which the trial court did find was incredible, which as to which there is this issue as to the Fifth Amendment. As Your Honor has alluded, this is an individual who took the Fifth at his deposition at trial. His lawyer actually took positions during the course of the trial to the effect that his client had never had any contact with Merrill Lynch. After the case is all over, facing a $16 or $20 million judgment, whoever's number you want to use, he does a deal with the plaintiffs saying, let me out from under this judgment, and I'll give you evidence against Merrill Lynch. That is what happened.
But this is, I understand that point. But isn't it fair to say this is not a case where the plaintiffs were aware of what Mr. Paley's testimony would have been had he not asserted the Fifth Amendment privilege? They were not aware.
So far as we know, they were not.
So that is newly discovered in that sense. It's not just newly available.
That's correct,
They
Your
were
Honor.
not aware and could not have been aware.
But that'll
Well,
always
although
be
it-
the case when somebody switches sides like this.
And in
So
particular,
that's a, kind of completely
But to whose
illogical.
benefit does that redound?
I'm sorry.
To whose benefit does that redound? In other words, as I understand it, a jury found against your client, correct?
That is correct, Your Honor.
And the judge entered a JNOV in your client's favor because she concluded that there was no evidence that Merrill Lynch or its agents had knowledge of the restrictive provisions of the agreement with Benistar, between the plaintiff's agreement with Benistar, correct?
That's correct. That's correct, Your Honor.
But in
essence,
fact, there is evidence that Merrill Lynch knew about it.
Well, there's evidence that, at best, that Merrill Lynch had knowledge that these were third-party funds. There is not evidence. Your Honor refers to restrictive provisions. If in fact, if you look at the documents that the plaintiff signed, there are not restrictive provisions. All it says is
That wasn't the basis of the judge's JNOV, correct?
That's correct.
And the
That is-
jury found against you.
Because the judge really didn't need to get to that issue, and the jury did find against us. That's correct, Your Honor. The judge subsequently found not only that there was insufficient evidence of actual knowledge, both of the fact that these were third-party funds, but that there was some restriction on the funds that precluded
There another
the trading.
Well, go ahead.
That precluded the trading of the sort that went on here, and that there was no sufficient evidence of substantial assistance, or as we contend and set out in the brief, 8-115 of the UCC.
Isn't that another problem with the Paley affidavit?
Yes.
If you accept it, Merrill Lynch had knowledge.
Of
But
knowledge that it was third-party funds.
Under the law of, I think, 2 different states, perhaps, where this applicable law, New York, Connecticut, you have to have affirmative evidence of assistance and collusion, and/or collusion, and his affidavit addresses none of that.
That's correct, Your Honor.
So that affidavit is deficient in that regard as well.
That is correct, Your Honor. And the judge, in deciding the JNOV, went through the pieces of evidence that plaintiffs said they had of substantial assistance, found each of them lacking. None of that deficiency with respect to substantial assistance, or we contend collusion, was corrected by Paley or Patterson, for that matter, the Paley or Patterson evidence. And on that basis, we've now, I think, hit all three grounds.
Out of curiosity, did you file a petition for rehearing in the appeals court when this error with regard to what Judge Botsford actually said with regard to or wrote with regard to the Paley affidavit?
We did
ended
not.
up exactly the opposite in the appeals court opinion?
We did not, Your Honor. We chose to file our petition with this court rather than pursuing it.
That was not good strategy.
Well, Your Honor, I think
Well, you're here, so you're here.
we're here. Our feeling was that we had certainly made it clear, both in our briefs and at argument, that that was what the court had said, and it was very clear in her opinion what she had said about the Paley evidence. And so the course we chose was to come here.
Okay.
And with respect to the let me just touch on 8-115. Our contention is that the trial court essentially held that the collusion standard, which is in 8-115. 8-115, to back up for just a second, is part of Article 8 of the UCC, designed to protect financial intermediaries, particularly in the case of securities accounts under Article 8, with respect to transfers and other transactions in accounts where they are acting on the instructions of the account holder, and where it turns out there are adverse interests. And what it says is the financial intermediary is free to act and basically must act on the instructions of its customer to the exclusion of any instructions it may get from others with adverse interest in the absence of a court order. The one exception to that is collusion. And we contend that the legislative history, if you will, of Article 8, and particularly of 8-115, and of the commentary and the language itself, collusion is a higher standard than the substantial assistance or participation under the aiding and abetting common law. Now, as Justice Greene has pointed out, the trial court has already found that the plaintiffs did not meet the standard for aiding and abetting, the common law standard. Our position is only with respect to substantial assistance. Our contention is with respect to collusion, they were even further away.
But I take it what the judge has done here, the trial judge, has said that, I mean, because the JNOV standard really is, there's really no evidence from which a jury could have concluded that there was whatever,
That's correct.
substantial assistance.
Could have reached a reasonable inference.
Right.
That's correct.
And the trial judge is basically saying, well, this evidence to me would create a sufficient, although thin, basis for that verdict.
Well,
So isn't that relevant? It doesn't establish it per se, but doesn't it add to the plaintiff's case sufficient that the jury should decide?
well, our contention is it adds only with respect, if you look at the evidence that we're talking about, the evidence from Mr. Paley and what he said.
Mr. Snyder, let me ask the question another way. I think it's the same, and you can just combine the answer to both. Then essentially, we have a jury trial here, correct? We have a jury trial.
Yes,
We
you're right.
don't have a judge trial. We have a jury trial.
That is correct.
And so the judge may not find Paley credible, but she could not have written a judgment NOV because there was no evidence. She wouldn't know whether or not the jury found Paley credible, but she would not have, even if they knew all about the bias and so on and so forth, she could not have written that judgment. She would have had to have said there was evidence, thin, but there was evidence that Merrill Lynch knew. And so surely the point, her whole discussion about where she says, it raises very substantial credibility issues, she's not suggesting that she wouldn't have permitted him to testify or there'd be any basis for him not to testify, correct?
At trial, Your Honor. Your Honor's hypothetical is that if, in fact, rather than taking the Fifth Amendment to every question,
He testified.
He had testified as he
Exactly.
did subsequently at the evidentiary hearing.
Right.
That is correct, but that is not the situation here.
And
What
would he, if he had so testified, might he have been liable for some kind of criminal conduct?
Perjury.
It doesn't, well,
But that-
other
but
than
that-
perjury, it doesn't seem
But
to me.
that's not the point. The point is, she said, if we were restricted to Paley's affidavit, I would not allow this motion. Then her enormous discretion not to allow it kicks in, and we wouldn't allow it either. So the point on whether, this evidence might have persuaded a jury to the other side of the coin is relevant only in light of what she did,
That is correct, Your Honor, and
with the possible error on the Patterson affidavit.
and the context of when she was doing it. That is, on a motion for new trial, the case law in this Commonwealth is clear that the court, on a Rule 60 motion, 60b2, is to take into account the credibility of
She
the
actually
newly
said
discovered
would not
evidence.
likely persuade me to the relief.
That's true. That is the exact quote of what she said. I agree with the comment that was made earlier. It might have been clearer, but it seems
No, it's
to us
pretty
that on the
clear.
face of that, it is quite clear what she meant. If she only had Paley, she wouldn't have granted the new trial. And she goes on to say, but here I have Patterson. Different matter. Let me talk about Patterson. So the point in response to the Chief Justice's question is, for the reasons that Justice Greene has said, in addition to the fact that here we're in a Rule 60b2 context, so whether or not she might have allowed JNOV at that point, if he had testified, is not really what we're faced here with. We're faced with meeting the standards under Rule 60b2, which include an assessment of the credibility of the so-called newly discovered evidence.
Except for the extent that you're making the point that even if he had testified, JNOV still should have been granted.
That's
That
quite
is
right,
the
Your
point
Honor.
you're making.
That's quite right, Your Honor,
And what's
because
your-
even if he had testified as he did at the evidentiary hearing, it would only have gone to actual knowledge that it was third-party funds, not actual knowledge
And
of
so
the
we're
restrictions.
questioning that. Let's
And-
put it
sorry?
that way. We are questioning that proposition.
You're questioning whether well, that was your question, Your Honor. That's
But we're
right.
questioning that proposition.
Yeah, you were questioning that proposition, and the answer to your question is, look at the evidence. Look at what evidence they had before on the JNOV that she found deficient. What does Paley add to that? And the answer to that is nothing on the issue of substantial assistance, as well as, we contend, on the issue of actual knowledge of the restrictions on this money.
Although she says if his evidence is believed, would be likely to affect the result. That's the trial judge.
That's what she says. She then goes on
I
to
know, I
say
understand.
later in the opinion, based on just his,
I mean,
he talks about his
in
credibility and then
essence,
says,
at very least, and this maybe, she should be asked to, except she can't. She, in the normal case, you would send it back, you might send it back to the trial judge to say, take another look at the JNOV, but I don't know of any case where we can enter JNOV on a different basis.
I think that's right, Your Honor. In this case, we don't think that would be the proper course because she has been sufficiently clear that language that you cited comes before her discussion of credibility, which is a factor she needs to take into account. Having assessed the credibility, she then says, regardless of what I may have thought before looking at credibility, after looking at credibility, I can't grant a new trial based on this
Alone.
evidence.
Okay. I'm not likely to. Thank you, Mr. Snyder.
Thank you, Your Honor.
Mr. Greenberg?
Gary Greenberg, and we represent the Benistar corporate defendants and also the Carpenters. I want to follow up on the, in terms of what Judge Botsford did in terms of the motion for the new trial. A fair reading of her decision, and recall that there was an evidentiary hearing, is that based on the evidentiary hearing, she did have significant questions about Mr. Paley's credibility. But she found that a jury could believe his testimony, and if based upon that, if a jury believed the testimony, it would have an impact as it related to the claims against.
But wasn't this before her on a 60B2?
It was.
Then that's a wholly different standard.
It is a different standard, but what she did, she looked at the entire context, having heard all of the live testimony. And our point on behalf of the Carpenters and on behalf of the Benistar defendants, if you look at Mr. Paley's testimony and you look at what the appeals court, the evidence the appeals court cited in support of the tort claims, and that's what we're talking about here. We're not talking about the contract claims. It's been determined that but for Payne Weber's conduct, there's an arbitration award which has been affirmed. It's Payne Weber's conduct which caused the Benistar to be unable to deliver the proceeds to these plaintiffs. So we have an award, as Judge Rainey, as you had referred to initially, in New York. There's been an arbitration award which said that Payne Weber, by selling out these accounts unlawfully, precluded the Benistar defendants from being able to deliver the approximately $10 million. The fundamental issue as it relates to the Carpenters and as it relates to the Benistar defendants is the tort-based claims, which were the basis for the 93A. The appeals court said, they said there's evidence in the record which supported that the tort-based findings. And what they talk about is they talk about that Benistar promised to hold these funds in escrow. They promised to safeguard the funds. They talk about Mr. Carpenter being responsible for the promotional material. If, in fact, you look at the testimony of Mr. Paley at the hearing, each of those pieces of evidence are contradicted by his testimony. Again, if a jury were to believe Mr. Paley at a subsequent retrial, Mr. Paley was the only person that had any contact with each of these plaintiffs. It was these pre-contract.
Well, I mean, maybe the only person who had plaintiff. I mean, we may have to disregard the Patterson documents, but is there any question in your mind that the failure to produce that was in violation of the discovery orders?
No, but for purposes of our request for a new trial, Your Honor, as it pertains to the Benistar and defendants, the corporate defendants, and the Carpenters, our point quite simply is all of the tort-based claims were based upon the plaintiff's statements as to what Mr. Paley told them. If you look at Mr. Paley's testimony at the hearing, he disputes everything. He says, I never told any of these plaintiffs there was no risk of loss. I never told them their funds were safe or secure. I told them we pooled our money, contrary to their statements. I told them, he said, he testified that Benistar's investment activities were consistent with all of my discussions, the terms of the agreement, all of the 1031 requirements. He said, I can't think of anything that I said to the plaintiffs that wasn't true. He also said, and this is
What did he
critical.
say about like kind?
He said that that everything I said to any of these plaintiffs in terms of like-kind exchanges, in terms of what the investments was, it was all consistent with the agreement, Your Honor. And under the 1031, under 1031, Your Honor, as we point out in our briefs, this whole theory that the plaintiffs could somehow control the funds would have eradicated the protections that 1031 provides. Our point, very simply, is the plaintiffs, having procured a new trial using Paley's testimony, they have to take the bad with the good. And there's a lot of bad for them. The bad is that Mr. Paley totally undercuts their tort-based claims, the conversion, the breach of fiduciary duty, the fraud.
But Mr. Greenberg, they may have to take the good with the bad, but that's not for us to say what is good and what is bad. That's a credibility determination. Nobody's suggesting this evidence cannot go before a jury.
And that's our point, Your Honor, is that the appeals court said in denying our request for a new trial, the district court, the trial court really didn't address it. The appeals court said there's plenty of evidence in the record, and they cite it. But what they don't cite is the fact that Mr. Paley testified the opposite way in the motion for the new trial. And I want to point out two things which are really critical. The 93A finding, which is critical in terms of the big liability, there's a 93A finding against Dan Carpenter. And the finding, the critical issue was, Mr. Carpenter is Connecticut-based. Okay? The principal finding, the trial court had to deal with primarily and substantially. And in terms of whether or not the misrepresentations of Mr. Carpenter were primarily and substantially in Massachusetts, the court draws an adverse inference because Mr. Carpenter had asserted his Fifth Amendment rights, as did Mr. Paley. The trial court says, in finding primarily and substantially, and it's the linchpin of the finding.
This is in the JNOV or the motion for the new trial?
This, Your Honor, has to do with the 93A finding, directly the 93A.
I'm sorry, okay.
The only basis for the 93A finding was that Mr. Carpenter engaged in a fraud, and the primarily and substantially requirement was satisfied because the court inferred that Dan Carpenter prepared the promotional materials and that Dan Carpenter prepared the form agreements that were used. And that's the sole basis for the primarily and substantially. Mr. Paley testified at the motion for a new trial that he prepared, that he was the only one that prepared the promotional materials, that he used his own agreements from his own prior employer. On a retrial, there would be no basis for the primarily and substantially to be satisfied because the linchpin of that finding was undercut by Mr. Paley's testimony. The same thing with respect to Molly Carpenter, who has nothing to do with Massachusetts. The court found personal jurisdiction over Molly Carpenter based upon an adverse inference when she asserted the spousal privilege. The court made the adverse inference that because she wouldn't testify, that she made fraudulent representations to the plaintiffs and that she traveled to Massachusetts. Based on those adverse inferences, they found that she was subject to personal jurisdiction. After the trial, when the court decided the 93A, the court found in the 93A decision that there was no evidence whatsoever that Molly Carpenter ever made any misrepresentation to any of these plaintiffs, that there was no viable connection with Molly Carpenter in Massachusetts. Again, there was no basis for any jurisdiction whatsoever as against Molly Carpenter. The adverse inferences that this court drew because of the spousal privilege and by Dan Carpenter's assertion of the Fifth Amendment turned out to be just totally wrong. The final point I do want to make.
I thought the basis was also not specifically to Mrs. Carpenter, as an individual, but because of her role as a director and the commingling and the crudely stated.
Actually, Your Honor, if you look at the decision on the motion to deny her motion to dismiss, the only grounds that they're relying upon is that they make an adverse inference that she visited Massachusetts and that she made representations to these plaintiffs. That's the principal grounds. The fact that she was an officer of a company that happened to have an office in Massachusetts, that doesn't give rise to her personal liability. She has to have done something. And those were the two things that the court seized upon. But then later on the trial, after hearing the trial evidence, and after having to make a decision on the 93A, the court goes 180 degrees the opposite way, never reconciling the fact that that's wholly inconsistent.
Mr. Greenberg, was there a separate J&OV with respect to Mrs. Carpenter?
I don't know, Your Honor.
But surely that was the opportunity to say to the trial judge, look, you've heard all the evidence, now we want to raise again.
Your Honor, this was, and I did not try the case, so I just can't represent. But I do know this was raised in the appeals court.
No, I understand that.
And but it's, if one looks at the record, one cannot reconcile the finding of jurisdiction.
Yeah, but nobody asked the judge, at least as you're telling me, to say with respect to Mrs. Carpenter, by the way, this jury verdict against Mrs. Carpenter shouldn't stand.
I don't know, Your Honor. I can tell you that
Okay,
the
I'll
court
check that.
in the noted when the court decided to disregard the corporate veil,
Yeah.
that attempts to contest jurisdiction had been raised multiple times
Okay.
by the defendants. Just the last point on the corporate veil issue. Essentially, there's a stipulation, Your Honors, that the plaintiff entered into that stipulated away personal jurisdiction. What they've done is they stipulate away personal jurisdiction, and then they ask the court to look at the merits of piercing to justify jurisdiction. If you look at the footnote on the course of Phase 3, which you will see that the court says in the footnote that, and I think it's footnote 6, it acknowledges that it has already found jurisdiction, okay, that had been challenged repeatedly. And it says we're not going to look at personal jurisdiction over these defendants. We're going to go right to the merits base. You can't, you first have to make a threshold determination as to whether or not these defendants are subject to the scrutiny of the court for veil piercing purposes. And that's the fundamental issue here, is that if you look at the court, we're right into liability.
Okay,
Then-
Mr. Greenberg, we get the point. But thank you.
Thank you.
Mr. Fleet?
Thank you, Chief Justice Marshall. I want to particularly focus on the Patterson evidence because we believe that the trial judge was correct in granting a new trial on that basis, and the appeals court was incorrect. But just a moment on...
Well, before you get
Yes.
going too far,
Right.
do you agree that the judge said that based on both affidavits, she was allowing the motion?
She says, and I'm reading on page 13, J13, that though she had, and this is the top of the page, though she had considerable doubts about the truthfulness of Paley's testimony, that was a question for the jury, and she is therefore ordering a new trial so that the jury can evaluate it. What we had done before her was ask that on the basis of Paley and Patterson, the verdict be reinstated. And she said, I'm not going to do that. I want the jury to look at it.
Well, I understand that she said, quote, although I believe Paley's evidence standing on its own would not be likely to persuade me to grant relief to the plaintiffs, when the Patterson evidence is added to the mix, the balance changes.
She says that as well, Your Honor. And it is added to the mix. And Commonwealth v. Grace, which we cite in our reply brief, Commonwealth v. Grace plainly states that evidence which perhaps is not admissible for new trial purposes, although we say Patterson clearly was admissible, may be used to bolster evidence which is being used for the purpose of the new trial. So she's precisely and exactly correct on Massachusetts law in making that conjunction. Even if Patterson is not independently considerable, although it is, and I'll argue that in a moment, it nevertheless may be, under the Grace case, used to bolster evidence which is somehow deficient. Now, turning to Patterson.
I think, Professor Mr. Fleet, we also have to take into account that this is a JNOV. So we have a jury verdict. We have a jury verdict. And so it seems to me that in evaluating whether or not you can take away a jury verdict, she has enormous discretion in deciding what she's going to take into account and what she's not going to take.
Well, I think that's precisely correct. And she said that. She gave that as one of her reasons. And it is also the contrast to all the cases outside of Massachusetts in the First Circuit on which Merrill relies. Because being criminal cases, necessarily they involve cases where the movement is seeking to undermine a jury verdict. We are seeking to support one. And that also weighed very heavily with the trial judge. Now, on Patterson, Merrill seriously overstates the fact when it says that that evidence was in our files, in our hands. All that was in our files was a cover letter stating that I am sending you the agreement and the exchange agreement. Those two agreements were not in our files because they were not handed over in Paley. The trial judge correctly found that that letter all by itself would not have been admissible. Now, it's quite possible with 20/20 hindsight to say, well, from that silken thread, you might have fished out of the ocean the whale of Gerald Levine's false, perjured testimony. Because Patterson, who is a completely reliable and objective and unconnected party, plainly testified, which is something, of course, we didn't have at that time, testified that he had a long conversation with Levine explaining to him exactly what the nature of these funds were, what he was expecting, and Levine had testified, surely untruthfully, he had testified that he had never had such a conversation with anyone.
Did he say he'd never had the conversation or he didn't remember?
Oh, well, on the new trial motion,
Oh, no, I
all of
understand
a sudden it
No, no, I'm
became a
talking about his
failure of
debit.
memory. But at trial, he said he had no such conversations. And
But I
of
take
course,
it in any event that there wasn't one, but there were multiple requests.
there were two requests. There were two, first before Merrill was a party, then after it was a Merrill was a party. And Levine specifically testified that they were meticulous at Merrill in maintaining this correspondence, and from that, we concluded that these documents did not exist. Now, maybe we made a mistake in believing Merrill's own witness. The more fool we, perhaps. But does it lie in Merrill's mouth to say that we did not use due diligence because we believed their witness? That seems to me a very odd contention. Now, the standard on due diligence.
I take it also, which is again in your brief, that in its opening, Merrill Lynch counsel said to the jury quite explicitly, these two agreements never saw the light of day at Merrill Lynch. In other words, Merrill Lynch never received them, correct?
It's like Rosemary Wood's 18-and-a-half-minute gap. How come? They meticulously maintain it. But there's this difference from the Rosemary Wood tape. We know what's in that gap. We have it. And we have Patterson's testimony. Now, it is the case that 60B2 does say due diligence. But note that word due. Other Massachusetts cases say due diligence is reasonable diligence. And there's one case which says it's a little bit like excusable neglect in 60B1. Now, excusable neglect is not absence of neglect, it's excusable neglect. And our proposition is that given Levine's perjured testimony, given the inexplicable absence of these documents, is it really the case that the trial judge abused her discretion, which is very wise, very wide, abused her discretion in saying, well, these people may not have used perfect diligence, they didn't have 20/20 hindsight, but it's reasonable, it's due, the oversight is excusable. Surely that is an appropriate use of discretion. And I call attention to the appeals court's opinion, which I think got this quite wrong. And this is in Merrill's brief at page A8. They recite all these facts, and correctly, because the trial judge recited them. And then, having recited them, they just jumped to the conclusion that there was a lack of due diligence. And to that I must say, I get it all except the therefore. There is no therefore. The therefore is just Judge Botsford's therefore, which is, though maybe in hindsight they might have pressed Patterson. By the way, if they had pressed Patterson, what would have happened is Patterson said, under attorney-client privilege, I cannot tell you this. I cannot tell you this. It's only later that his client released him and allowed him to come to us. Obviously, because he was...
Mr. Freed, the attorney-client privilege would have prevented Patterson from disclosing the attachments to the letter he sent to Merrill Lynch?
His client did not allow him to participate in this proceeding at all. Perhaps, again, I say perhaps, and this is only contrary to fact, in any event, perhaps we should have pursued this. But was it a lack of due diligence to believe Merrill's own witness? And should we now...
Did Patterson's letter refer to the documents that were signed?
The cover letter did say, I am sending you the exchange agreement and the agreement. That is correct.
Did you folks go get those agreements?
From Patterson?
Well, let me... from anybody.
What we did, we tried very hard. Twice, as Chief Justice Marshall pointed out, twice we asked for any such documents that Merrill might have in its files. And we were told they're not there.
Couldn't you have gotten them from the Benistar, from your own folks?
No, they had the agreements. The question was, could they show that Merrill had the agreement?
Well, that's the point. They, of course, we have no doubt what the agreement said. The issue was, did Merrill know what the agreement said? The fact that we know what the agreements are is irrelevant. Of course we knew what they were. And the whole issue was that Merrill claimed they never heard of this. We have no idea. Levine kind of changed his tune when he was faced with the Patterson testimony, which, by the way, was exactly the same as the crucial Paley testimony. I should simply say
Mr. Freed, could I just ask you a question? On the issue of like kind, I take it that it's your client's position that even without the two particular agreements, if you understand like kind and then you list in your brief the evidence that supported the jury finding that Merrill was on notice that these were like kind funds, I take it, well, is it the case that the kinds of investments that Merrill was undertaking with your client's funds were inconsistent with like-kind investments?
Oh, they certainly were, and Merrill opened corporate accounts here which allow this kind of trading. It's perfectly clear that Merrill could not have opened that kind of an account if it had taken account of the fact that these were property exchanges. There's no doubt about that. And we do, and before my time has expired, I would like to say that we do rest on our brief in respect to the JNOV because we think that there was sufficient evidence to infer that Merrill's knowledge. And I think here Merrill greatly overstates 28115. 28115 does say collusion. The comment to 28115 says that means aiding and abetting and refers us to the restatement of second torts, Section 876, which says substantial assistance, which is exactly the standard which the trial judge used in instructing the jury. I thank the court
I'm
for its...
confused, Professor Freed. One question. The JNOV, the question of the appropriateness of the JNOV is not before us, is it?
It is certainly before
Yes,
you,
it
Your
is.
Honor. It is
It
because,
is a matter on. Go ahead.
because we appealed it. We appealed it to the appeals court, and we certainly did. I recall discussing it with the appeals court, and
And you lay it out in your brief, right?
Well, it's laid out in the brief, but
it's featured rather heavily in our brief.
No,
to
I
this
know
court.
it is, and I read the brief, and then I was surprised to see, I thought, that we accepted this only for a few issues.
No,
I don't think
no,
we...
Your Honor, I don't believe that's so. There was a discussion with the clerk's office about Payne Weber's presence, and the clerk wrote us stating that, well, as to a party, that drops out. But I believe it's clear law in this court that where there is an appeal, the
was
appeals
no
court
issue.
drops out, and it is exactly as if we were
There
appealing.
was no issue limitation as to your client.
There was no issue limitation. That is correct.
Thank you, Mr.
I
Freed.
thank the court.
Mr. Zell?
Thank you, Mr. Chief Justice. May it please the court, to answer your question, Mr. Corey, in our opposition to the petition for direct appellate review, we did note, and I believe it is footnote 3, that we would bring to this court's attention the JNOE issue if...
What did you seek further appellate review on? I don't want to complicate the question. What did you seek further appellate review on?
We simply said, Your Honor, that if this court takes further review, that we would present all of the issues that we raised.
Okay, that's what
But
you said. in your
she
petition.
reported it, didn't she? So that takes care of all this snafu, if there is one in the first place. She said, I'm reporting the NOV
Yes, Your Honor.
question.
That's right.
That's right.
All right, settled.
Let me begin by answering the Chief Justice's question with respect to the JNOV. Specifically, there were 6 categories of evidence, and remarkably, Merrill Lynch's brief refers them as only 6 categories of evidence. But there were 6 categories of evidence which were presented to support the JNOV decision. I won't detail them, but
the
I will...
jury's verdict, you mean?
I'm sorry. That's right. That supported the jury's verdict. They are set forth in our blue brief at pages 27 and 28, and in our reply brief at pages 6 and 7. In quick summary, there was evidence that supported, or that would have supported, a jury's conclusion that the Merrill Lynch brokers had actual knowledge that the money in the Benistar accounts belonged to other people, that it was to be held in escrow. And again, as the Chief Justice noted, that in and of itself is sufficient to create the knowledge that it was improper to use the money for option trading, highly risky option trading.
What about the assistance?
The assistance was established in 2 ways, Your Honor. First of all, by virtue of the fact that Merrill Lynch's brokers, Levine and Stern, concealed from compliance the true owner of the funds and the true owner of the account. Specifically, there was a memo from compliance that said, what is this account holder doing? What is their business? And the response was, well, Daniel Carpenter owns a lot of businesses, and one of them is real estate development, but they concealed from compliance, and the option trading went on for that very reason. As important, Your Honor, is the fact that when the jig was up, when Mr. Carpenter wrote to Merrill following the closure of the accounts and said, you can't close down these accounts, these are the depository funds of Benistar's clients. What Merrill did was they perpetuated the scheme. They facilitated the continuing option trading by Carpenter using the Benistar clients' funds by contacting a broker at Payne Weber with whom they were friendly, and they thereby facilitated the continuation of the trading.
And all this was at the trial.
All this was trial
So
evidence.
she should not have even tinkered with the NOV. She
That's
should
our-
have flat out denied it.
I take
right,
it your position, Mr. Zell, is that when she says, as she does in her memorandum on the JNOV, that neither Stern or Levine, the immediate brokers, Thomas, the branch manager, or anyone else at Merrill Lynch knew or was made aware by Carpenter or any other person that, in fact, the Benistar property option trading accounts belong to the clients of Benistar, you're saying maybe not by a person, but there was plenty of evidence just in the nature of the accounts, the letter to Merrill describing the funds as the depository funds, the account opening documents that listed them as the Benistar Property Exchange Trust Company, which I take it as a term of art.
There is, in fact, Your Honor, a New York statute that governs the use of the word trust in the title of a corporation.
Okay, and so on and so forth. I mean, so
What you're
the gist of your argument is that those conclusions of hers are not correct.
That's right.
But what you're saying is a very experienced judge would have to slip through the whole trial.
Absolutely not, Your Honor. What I submit is that it is a very technical issue that led her to grant the JNOV, and it is one that Your Honor wrote on in the Geisler case. And in that case, Your Honor, you distinguished between evidence of, in this context, evidence of disbelief. This is what the trial judge held. Cannot affirmatively establish the contrary proposition. And what Your Honor said in the Geisler case is perhaps not, but it certainly is state-of-mind evidence upon which the jury can rely. And in our case, the simple fact that there was a denial by Levine, which was disbelieved, was not standing out there on its own. It was supported by the 6 categories of circumstantial evidence that was presented at trial. And we submit that when it comes to state-of-mind evidence, there is but only one reasonable inference that can be drawn from disbelief, the statement, I didn't know that.
I take it in any event that Levine and what the trial judge points to is, and I haven't read the trial testimony, so let me be frank about that, that Merrill testified, that is, Levine, Rasmussen, and Kevin Duffy, whoever he is, indicated they didn't understand the reference to depository for our clients, that's in the Rasmussen lesson, and had they been confronted with the Patterson evidence, they would have known that Levine was lying.
That's absolutely correct,
If
Your
he was
Honor.
saying affirmatively that he never had a conversation, he didn't know about Benistar, I don't know what he testified.
Well, that's correct, Your Honor. And if I may take that point one step further, Merrill's own procedures include a definition of depository funds. So, again, the jury certainly had a good faith basis or a sound, rational basis to determine that they, of course, knew what depository funds meant. It's written in their own documentation.
Thank you, Mr.
Thank
Zell.
you, Your Honor.
We'll take a short break.